We're going to go now to a video, if I understand correctly, of Catharine MacKinnon from the International Criminal Court.
The embrace by the international community of the concept of gender crime in a remarkably short period of time is reflected across the UN system and most explicitly by the International Criminal Court. Its Rome Statute recognizes gender crimes explicitly as a basis for persecution and implicitly as rape, sexual slavery, forced prostitution, trafficking, and other acts across its war crimes, crimes against humanity, and as an act of genocide. It also impliedly recognizes it beneath the text, as was revealed in the Lubanga case, where in an example of gender mainstreaming, the prosecutor argued that being taught to rape as well as being raped harmed the child soldiers. On all of these levels, gender crime has evolved in a short 25 to 30 years through the interaction of civil law on the one hand and criminal law on the other. Domestic and international human rights and civil rights structures have incorporated crimes of violence against women. This has interacted with the criminal law, principally on the international level, which has returned the favor by incorporating gender analysis into its treatment of what formerly were sex crimes, this arriving at its apex form in the International Criminal Court. The central insight of this area, of this development of gender crime, originated in sexual harassment law in the United States, was then expanded upon by the CEDAW Committee, accepted in human rights cases and instruments in the regional systems of Europe and Latin America, and recently in Africa. Then also given depth and dimension by the ICTR and detail by the ICTY. And finally, the idea took root in its highest codified expression to date, that is the Rome Statute. Now, the fundamental idea here, as most of you know, is that sex crimes are gender-based. That means they happen because of the social meaning of sex, being a woman or a man in social context. Crimes that happen because of gendered roles, meanings, stereotypes, and scripts assigned to groups on the basis of their sex thus become criminal forms of sex discrimination, crimes of gender inequality. Among other things, this means that although individuals who are victimized by these atrocities are sometimes, even often, violated alone and in isolation and one at a time, the violation itself is intrinsically collective and group-based rather than individual. Everyone who is raped is harmed personally, but rape itself is an attack on a woman because she is a member of the group women, targeted and defined for this specific violation as such. As it has evolved, this substantive legal development is altering major technical rubrics all along the way, including the state versus private actor distinction. It is challenging some accepted doctrines of jurisdiction and sovereignty. It resists many cultural practices and walks right across the line of war and peace. Put another way, addressing gender crime, which concretely means largely women's legal and physical abuse by men, calls into question legal notions that had previously appeared gender neutral. In light of the information on systematic violence against women by men that the international community has generated over this same period of time, and accompanied by the legal impunity for these acts in so-called peace, as well as in war, that has been exposed at the same time, these doctrines have been revealed as anything but gender neutral. In light of these observations, and with positive complementarity especially in mind as a goal, that is, where the relation between the International Criminal Court and the rest of the world becomes a productive two-way street. What this process continues to encounter is, and this is a form of a barrier, is layers of exceptionalism that still too frequently, I think, surround the notion of gender crime. People often think of crimes as exceptionally bad acts committed by exceptionally bad people under exceptionally bad conditions. The criminal law in particular has a tendency to think that it is or should be addressing exceptionally bad acts, often termed acts of extreme brutality. This approach obscures the brutality of the normal and the normality of brutality. The more brutality is exposed, the more it can also work to set the bar to prosecution and conviction too high, to put it another way. Also fairly pervasive, there is the notion that the perpetrators, or those we should be most interested in as perpetrators, are exceptionally bad guys with exceptional amounts of power. And some of them surely are. But in light of a gender analysis, they are hyperconformists, not deviants, carrying the flag and bearing the weight for gender norms and gendered acts that neither begin nor end with them. This fact does not undermine their responsibility, of course. If anything, it underlines it. Along similar lines, the women of each place and of each conflagration, I have noticed by being in touch with so many of them, are often just absolutely certain that they live in an exceptionally bad place or time, and that their context is exceptionally backward as to stigma or corruption. In a global context, the barriers they encounter are always specific, but everywhere there are barriers. And finally, there is the idea that the situation most urgent to address must be the exceptionally bad situations, which are thought to begin and end, after which we have an aftermath, a transition. Again, this is true sometimes. But for gender crime, that pattern is the exception to the everyday rule in which people are pervasively being violated on the basis of their gender in a war that has yet to end, ever, anywhere. Once we realize all of this, the opportunities are open to us to confront how sexual abuse happens, to expose the different work that it does in a variety of contexts, to take on its atrocities internationally, to inspire and support domestic legal settings, and in so doing, to begin to change realities on the ground. This method has already redefined rape realistically, for once, in the Akayesu case. It has gotten gender recognized as a statutory basis for persecution, which it always has been. It has recognized that some sexual violence can be an act of torture or a tool of genocide. And in every prosecution brought so far before the ICC, gender crime is recognized as a crime against humanity, a weapon of war, or a tool in a genocide. There is room for a great many more creative applications to come. I believe that we can, and perhaps will, end gender violence as a normal, everyday matter in our time. I wish you all the very best in your deliberations. Stay in touch.